Good afternoon again. My name is Silvana Pavlovska and you are watching In Focus with Silvana Pavlovska. Continuing the series dedicated to the Macedonian question and in particular Prof.d-r Igor Janev's work, which is titled The Prespa Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty, a 2023 publication. And now we are going to commence chapter 5, and it reads as follows. A possibility of individual or collective action to sue both the Macedonian and the Greek government for violations with respect of the minority rights of the Macedonians in Greece due to the obligations stemming from the Prespa Agreement. As we have explained in our previous chapter, the Prespa Agreement unjustly and illegally deprived the Macedonian people from their minority rights in Greece, so that their mother country, that is the Republic of Macedonia, have legally nullified their national identity, claiming in accordance with the PA that they do not exist as their ethnic nationals in a manner that the home country, Macedonia, cannot protect the national minority rights. In accordance with the Prespa Treaty, or PA as is known, present-day Macedonia has revoked and denounced any rightful claim that these people, that is the Macedonians in Greece, were their minority and or belonged to the Macedonian people as national minority of any foreign country. I shall just read that bit a little bit. So, in accordance with the Prespa Treaty, present-day Macedonia has revoked and denounced any rightful claim that these people, that is the Macedonians in Greece, were their minority. And similarly, Greece, on the other side, have not recognized these people as national minority of any foreign country. That absence of recognition is based on unrecognized national identity by the Prespa Agreement, Greece, and hence deprivation of that ethnic group from its identity as a basic right. Therefore, identity of these people, these ethnic Macedonians in the Hellenic Republic, in accordance with the Prespa Agreement, remained illegally unrecognized and dismissed, hence nullifying that group as a minority with its collective rights, including rights of pertaining to national minorities. I don't know whether you can follow this, but this Prespa Agreement, this is myself, based on my own understanding, summarizing what this means. The signing of that Prespa Agreement means Macedonians residing within the borders of what we know the Hellenic Republic nowadays do not exist. And because they do not exist, they don't have any rights. On the other hand, we've got the Macedonian government that is part of this so-called North Macedonia, does not acknowledge that there are Macedonian people in Greece that belong to the same ethnic nationality. So you've got both Greece and Macedonia nullifying the existence of these people who are Macedonian, okay? But this is what's happened as a result of the Prespa Agreement. In order to protect ethnic Macedonian nationality people who are living within the borders of Greece, and that's a large minority of the population in Greece, bearing in mind that their rights were not recognized both by Greece and the Republic of North Macedonia state. After the conclusion of the PA, individuals and groups may attempt to sue the government in the European Court of Justice for deprivation of national minority rights as a result of the implementation of the PA. So this is Professor Igor Janev letting us know that those people who are Macedonian are living within the borders of Greece as a result of the Bucharest Agreement from 1913 dividing Macedonia between Bulgaria, Greece, and so on. If those people who are Macedonian are not recognized as such in Greece, and neither are they recognized by the Prespa Agreement from this North Macedonia concocted state, then such people, individuals and groups, can take legal proceedings against the government in the European Court of Justice, because they have been deprived of their national minority rights as a result of the Prespa Agreement. This information is very crucial. And if you are listening to this in Focus with Silvana Pavlovska broadcast, and in particular this section, if you have any questions, please by all means send them to us, and we're happy to convey them to the professor. You might be able to get some responses to those questions and how to go about taking legal action. They could invoke the instruments, says the professor. They could invoke the instruments such as the Framework Convention for the Protection of National Minorities. So here, the good professor is telling us what can be done. We can invoke the instruments such as the Framework Convention for the Protection of National Minorities, delivered by the Council of Europe in 1995, or similar international instruments suitable for the protection of the national minority rights, particularly if they are applicable for European courts' jurisdiction. The Framework Convention for the Protection of National Minorities provides in Article 3 the following. 1, quotation. Every person belonging to a national minority shall have the right freely to choose to be treated or not to be treated as such, and no disadvantage shall result from this choice or from the exercise of the rights which are connected to that choice. 2, persons belonging to national minorities may exercise the rights and enjoy the freedoms flowing from the principles enshrined in the present Framework Convention, individually as well as in community with others. End of quote. Other important substantive principles and norms embedded in this instrument are: 1, promote the conditions necessary for minorities to maintain and develop their culture and their identity. 2, encourage tolerance, mutual respect, and understanding among all persons living on their territory. This is Article 6. I'll just repeat the first one. Promote the conditions necessary for minorities to maintain and develop their culture and identity, which pertains to Article 5. Encourage tolerance, mutual respect, and understanding among all persons living in their territory, Article 6. Protect the rights to freedom of assembly, association, expression, thought, conscience, and religion, Articles 7, 8, and 9. Facilitate access to mainstream media and promote the creation and use of minority media, Article 9. Recognize the right to use a minority language in private and in public and display information in the minority language, Articles 10 and 11. Recognize officially surnames and first names in the minority language, Article 11. Endeavor to ensure the right to use the minority language before administrative authorities and to display bilingual topographical indicators in the minority language in areas inhabited by national minorities, quotation traditionally, or again, quotation in substantial numbers. Pertaining to Articles 10 and 11, foster knowledge of the culture, history, language, and religion of both majority and minorities, Article 12. Recognize the rights of minorities to set up and manage their own educational establishments and learn their own language, Articles 13 and 14. Endeavor to ensure that there are adequate opportunities to be taught in the minority language in areas traditionally inhabited by national minorities or where they live in, quotation, substantial numbers, Article 14. Quotation, create the conditions necessary for the effective participation of persons belonging to national minorities in cultural, social, and economic life and in public areas, in particular those affecting them. End of quote, Article 15. Refrain from measures that alter the proportions of the population in areas inhabited by the minorities, Article 16. Not interfere with the rights to maintain contacts across frontiers and participate in the activities of national and international NGOs, Article 17. Without national identity as a legal identity, neither of the above enumerated rights could be enforced or implemented. As we may also conclude, says Professor Igor Janev, a further development of the legal instruments such as the Framework Convention or other acts based on it could serve as grounds that have potential to put down or disable the Prespa Agreement. Considering all practical future aspects, we may derive the final conclusion that if legal instruments exist that could be used by the European Court, that is action remedy, there would always be a group of individuals that will challenge the legality of the PA and its provisions in the European Court. These aspects, providing for possibility for an individual claim and actions against the Prespa Agreement in the European Court, give us a more hope that one day the Prespa Agreement would indeed cease to exist and be nullified or terminated. So that was the end of chapter 5 of the Prespa Agreement as cultural genocide of the Macedonian national identity, a scholarly publication by eminent Professor Dr. Igor Janev, and it's been part of our series on the Macedonian question. Now, next episode on next broadcast will include chapter 6, which will be the conclusions and final recommendations from Professor Dr. Igor Janev. We thank Professor Dr. Igor Janev for allowing In Focus with Silvana Pavlovska to bring this to the attention of the public in the English language. So I shall look forward to seeing you very soon. Have a lovely day. Bye for now.